as an organization, as a company, you do want to have a social media policy. And typically, you're going to try to regulate conduct around use of your organization's network, regulate any conduct that's done on behalf of or is attributable to your organization, your company. And the trickier part is really, what about the off-duty conduct? You know, as I mentioned with that Oakwood, hospital incident, I'm sure that at that point the nurse felt, well, I'm on my own time. I'm not at work. I'm using my personal account, but yet what she did impacted her job. And as I said, the NLRB has, they have an interest in making sure that employers are not making their policies or their restrictions on employees too broad, because they want to protect not only the employee's right to organize, but also the employee's right to discuss terms and conditions of employment. And if you think about that, that's a pretty broad category. Terms and conditions of employment, well, that could include salary information that the employer thinks is confidential. But the NLRB doesn't view it that way. So one of the things they did recently, one of the administrative law judges for the NLRB actually overturned substantial portions of Kroger's policy, social media policy, and their disclaimer. They had a disclaimer that they were requiring employees to put on their personal social media accounts, saying that it didn't reflect the views of Kroger or anyone who was employed by Kroger, and the NLRB actually struck that down. So you have to craft your policy with care. I think some of it maybe can't be mandatory, has to be suggestive rather than mandatory, but I think it's still important to have it. And you need to make sure that it's going to coordinate with other policies that you have at your organization and at your company.